back to my channel. Blake Lively's new movie Another Simple Favor premiered yesterday on Amazon Prime, released directly to streaming, and it has sparked a wave of media headlines. She appeared on Seth Meyers last night, and unsurprisingly, her remarks did not come without consequence. During the interview, she made a statement addressing her ongoing lawsuit with Justin Baldoni. When I say there were consequences, I mean that any public statement she makes can and will be used against her in court. One of the allegations in this lawsuit is that Blake is engaged in a smear campaign aimed at damaging Baldoni's reputation and seizing control over the rights to the film It Starts With Us. Her end goal remains unclear, but I found it strange that she used her children to frame the emotional tone of her statement. She said something along the lines of, "I'm leaning on my kids right now, they're my only source." And Seth Meyers responded with, "Since you brought it up, would you like to say something?" The moment felt incredibly scripted. She then gave what appeared to be a rehearsed monologue, presenting herself as a spokesperson for all women. But in my opinion, she's not that. Blake Lively's narcissism was on full display throughout the Seth Meyers interview. In my view, both she and her husband Ryan Reynolds are incapable of resisting the spotlight. For example, look at how Ryan recently made an 8-minute speech at Green Day's Hollywood Walk of Fame ceremony, where he barely spoke about Green Day and instead centered the moment on himself, despite having only met them a year or two ago while filming Deadpool and Wolverine. It felt like he may have been the reason they got the star in the first place. That moment, like so many others, became all about him. Similarly, Blake used her media moment to focus on her own victimhood and portray herself as a martyr. This is a common tactic among covert narcissists, playing the victim and manipulating sympathy to serve their own interests. It's clear to me that Blake and Ryan are currently misleading the public, and Another Simple Favor is just more evidence of that. The movie itself is awful, truly terrible. I watched it only because it was free with my Amazon Prime subscription. The plot was chaotic and confusing. I couldn't even understand why Stephanie would be in Capri. Despite claiming to be a co-lead, Blake barely appears in the film. I was genuinely surprised by how limited her screen time was. In one scene, her character threatens to sue another character, Anna, into oblivion for using her name and likeness. Lawsuit threats are a recurring theme in the film, and she even talks about destroying people. I'm not sure when those lines were written, whether they were added in post-production by Paul Feig, but they struck me as highly inappropriate given Blake's real-life $400 million lawsuit. If you're embroiled in such a serious legal battle, why say things like that publicly? To make matters worse, the movie is bizarre. Blake plays twin sisters Emily and Charity, identical triplets, actually, though the third sister was supposedly killed in the previous film. Charity, who was believed to have died at birth, is alive and mentally ill. She was raised by her Aunt Linda, and it's clear that Charity has an obsessive and disturbing fixation on Blake's other character. In one unsettling scene, Charity fondles Blake's character while she's unconscious. Yes, it's Blake's character doing this to another version of herself, likely using a body double. It's disturbing and disgusting, yet no one in the media is addressing this scene. They're acting as though this movie is some kind of triumph, and I'm sitting here wondering, this is what we're celebrating in 2025. Paul Feig, gross. The sequel wasn't even based on a book. It was a script created by Paul himself. Blake previously accused Justin of trying to insert obscene content into the movie, yet she starred in a film that included this kind of material. Notably, Blake had no intimate scenes with others, only with herself, which may have been a calculated choice. Even her on-screen marriage is presented as a weird situation for a secretly gay husband. The subtle suggestions seem almost mocking. Are they implying something about Ryan Reynolds? I don't know, but it felt like Blake had a much larger role in crafting this script than Paul Feig would like to admit. Meanwhile, she continues taunting Baldoni on Seth Meyers in the movie itself and through media appearances. These are not the behaviors of someone who is a victim of sexual harassment. True victims don't act this way. What I see is someone entitled, using her platform to destroy Baldoni. And I don't think she'll stop, because she seems determined to style herself as an advocate. But here's the problem. Last August, she had an opportunity to speak out for domestic violence victims, and she stayed silent. Why now? Why choose this moment to speak up? The timing feels manipulative and calculated. As someone who's spent years advocating for media transparency, this situation frustrates me. I started covering Sister Wives because I was outraged by how the mainstream media normalized polygamy without addressing the abuse. I've exposed how the Duggars use their platform to promote dangerous ideology. I'm tired of being gaslit by Hollywood elites who care more about their image than the harm they're causing. The mainstream media doesn't challenge these narratives. They act as publicists, not journalists. Aside from Billy Bush, I haven't seen one member of the press question any of this. And that's a massive failure switching gears. Yesterday, I talked about the case developments, specifically how Stephanie filed a motion to compel. I said it felt premature and was likely a strategy to get before the judge, reminding them of her motion to dismiss. Some of you in the comments pointed out that she also filed a request to stay discovery, making this motion seem contradictory. Does she want to pause discovery or compel it? Now, Wayfair has responded with a letter to the judge. It's concise and confirms many of the points I raised yesterday, which suggests I'm reading the legal situation accurately. The main claim from Wayfair is that the Sloane parties already have notice of the claims against them. The amended complaint states that they made defamatory statements to third parties, including the New York Times, alleging that Baldoni is a sexual predator who retaliated against Lively. They also claim that false and misleading narratives were spread to damage his image and reputation. According to the complaint, the Sloane parties misled the media, framing Blake as a victim and Justin as the villain. They seeded false information to outlets like the Daily Mail to support their narrative. In terms of false light and defamation, Wayfair argues that Blake and her team intentionally misrepresented the on-set situation to harm Baldoni. They claim her PR team led by Leslie Sloane coordinated this media push. There's no public statement from Leslie in the New York Times article, but it's implied she orchestrated it. Blake's statement in the article claims her legal action is meant to expose sinister retaliatory tactics and protect others from harm. She denies planting negative stories, but the article notes she used subpoenaed emails and texts obtained through a now questionable lawsuit. The Times didn't show the full text conversations. They edited them for length, which raises transparency concerns. If you're truly exposing wrongdoing, why not release full texts? Also, Sloane's interrogatories seem overly broad, and Wayfair is pushing back. She wants Justin personally to be compelled to answer, even though he isn't Wayfair itself. Wayfair notes that they've already disclosed over 150 people connected to the case. That's a huge number. Wayfair also argues that Sloane knows exactly who she spoke to and what she said. She has her own emails, her own records. If there are defamatory comments, she made them so she knows. Their point is that she's asking for information she already has. As I said yesterday, this is a strategy to stall and control the narrative. She doesn't want to be pinned down because that would expose the manipulation she's been engaging in all along. They are requesting all the evidence that may come along with a second amended complaint, a document that they have not filed. They mention a second amended complaint, but such a document does not currently exist, may never exist, and, of course, has not yet been filed. The Wayfair parties objected on the grounds that the request seeks information that is protected from disclosure by attorney-client privilege, the work product doctrine, and any other applicable privileges. They also objected to the request as being premature. As I previously said, it is indeed premature because a second amended complaint does not exist at this point. The cases cited by the Sloane parties support only the unsurprising point that a party must produce documents referenced in its pleadings. If and when a second amended complaint is actually filed, then they will produce all non-privileged documents that are relevant to the claims located through a diligent search, so long as those documents have not already been produced. This would include any document referenced in such a currently non-existent pleading. I really appreciate how clearly they highlight the fact that she is asking for something that has not been filed, and they are reinforcing that point effectively. The final portion of this argument echoes exactly what I said yesterday. They respectfully request that the court deny the Sloane party's motion to compel. The unfortunate truth is that the Sloane party's real intention behind filing the motion is not to compel discovery, but rather to re-argue their pending motion to dismiss, which they anticipate will be denied, especially in light of the court's previous denial of their motion to stay discovery while the dismissal motion was pending. Didn't I say exactly that yesterday? They're trying to get the judge to remember that they filed a motion to dismiss because they seem to suspect it won't be granted. If you truly believed your motion to dismiss would be successful, why would you be pushing to compel discovery? The only logical explanation for filing a motion to compel in that context is because you sense your dismissal motion won't be granted. For anyone wondering about the rules that govern how judges handle motions to dismiss, the timeline in this litigation currently sets trial for March. However, the chance that the trial will actually happen in March is extremely slim. It is very rare for civil cases, especially in federal court, to go to trial on the originally scheduled date. More often than not, these cases take years to proceed through the court system, whether in federal or state court. Being frustrated after 4 months is premature because this case could very well drag on for 3 or 4 years if it doesn't settle. As for the judge's timelines, under federal rules, a judge must either rule on a motion to dismiss or set a hearing within 6 months. Sometimes judges schedule hearings for oral arguments, where each side can present their points. In this particular case, it appears that such a hearing will not take place. If that's true, the judge will then issue a ruling within 180 days. Leslie's motion was fully briefed around mid-March, which means she's about a month and a half into that timeline, leaving 4.5 more months. Many federal judges do not rule before they are required to, because they're busy. Unfortunately, in the Southern District of New York, judges have far more critical matters to attend to, particularly criminal cases with actual victims. These types of cases typically take precedence and move faster than civil cases due to the federal speedy trial guidelines. So, it's very likely that Judge Lyman is managing multiple cases right now, many of which are more urgent and important than this one. It's also likely that other motions to dismiss in different cases are awaiting his review. So, for her to suggest that this motion should be decided immediately is simply unrealistic. I would guess that the motion to dismiss won't be ruled on until the very last moment of the 6-month window. Judges tend to use the full amount of time they're given and rarely rule earlier than required. That has consistently been my experience in both state and federal courts. I like that they're pointing out exactly what I've been saying, that she is asking for materials based on a complaint that hasn't even been filed, which shows she's probably panicking. It seems like she's trying to re-argue her motion to dismiss. When something is sub judice, meaning it's still under judicial review, it should not be addressed again in a separate filing. That's another reason this behavior is being flagged. Since the judge has not yet ruled, it's inappropriate to raise the issue again in another motion. If the court sees that this is an attempt to re-argue the dismissal motion through a discovery filing, that can be seen as an abuse of the judicial process and its resources. This reminds me of Todd Crisley during his criminal case. The mainstream media avoided covering his legal issues because he constantly threatened to sue reporters. Most outlets didn't want to deal with that, so they stuck to fluff pieces. I wouldn't be surprised if something similar is going on here.